Hey, everyone. Welcome to another Substack Live. I'm here with the redoubtable Adam Klasfeld of All Rise News, and we want to talk about the Kilmar Abrego Garcia case, where a lot has been happening in general, and then this morning, to cap it off, a pretty important and possibly pivotal document was unsealed from Judge Crenshaw, who is handling the criminal case. I'll just set out where we are generally and then turn to Adam to talk about this new document and what it portends. But the judge has already made it clear he took the trial off calendar, finding that Abrego had made a preliminary showing that the criminal charges against him were vindictive and they were in retaliation for his successful efforts to evade the U.S.'s detention and in the criminal trial itself. And so what we have now, instead of a trial in a week or so, is a hearing at the end of January, where the presumption is already enjoyed by Abrego, and the U.S., if it chooses to go forward, will have to rebut it in order to show it's not a vindictive prosecution. And that could involve a real tussle over evidence and people on the hot seat, which is exactly what the new document Unsealed today shows. Adam, as always, I think both of us have really focused on this case a lot, but he, as in so many pending cases, really covers the waterfront and closely. So he's all over this just released document. Adam, give us the sort of skinny on it.
So thank you for the terrific introduction, Harry. You really set the stage, because what this document shows, now this was a document, it was a sealed ruling that was released without any sort of context earlier this month, with instructions that it would be unsealed today at noon Central Time. And what it contained was an order for Judge Crenshaw for the release of evidence that was internal deliberations between Main Justice and the Middle District of Tennessee about what was going on behind the scenes in those pivotal moments between the Supreme Court ordering the government to facilitate Abrego's release back in April and Abrego's indictment in May. And now, for the first time, we have a peek under the hood of what those communications were like. And we have from the chief aide for Todd Blanche saying that prosecuting Kilmar Abrego Garcia was, in his words, a top priority. That's 20 days, exactly 20 days after the Supreme Court ordered Abrego's release from Secot Prison in El Salvador. We have an email from Akash Singh, who is a chief aide to Todd Blanche, saying, quote, it's a top priority. And McGuire, who's the acting U.S. attorney for the Middle District of Tennessee, writing back on that same day, quote, we want high command looped in. It's an extraordinary document. It was released today because Judge Crenshaw found that these files go to the heart of the vindictive prosecution case that Kilmar Abrego Garcia and his attorneys have been making. Because let's take a quick step back here. The reason that Kilmar Abrego Garcia was able to establish the need for a hearing on vindictive prosecution was that Todd Blanche went on Fox with Laura Ingraham and said that the reason for this case was that a judge questioned their decision to spirit Abrego out of the country in mid-March, because Todd Blanche said that on air, on national television. Judge Crenshaw thought that was such an extraordinary statement that warranted meeting that high bar to get a vindictive prosecution hearing. And as someone who's covered many criminal cases for nearly 2 decades, I've never seen a criminal defendant establish that bar. Getting to that point, getting to the point of a hearing is extraordinary enough. And to meet that distance that the judge found would get to the point of proving vindictive prosecution, they'd have to show a connection between the charging decision and that statement from Todd Blanche. And here's the connective tissue in these documents. I've only quoted a couple of those emails so far, but these are communications between Todd Blanche's top deputies in the office of the Deputy Attorney General and the prosecutors who made the call. The same prosecutors, U.S. Attorney McGuire, had been insisting that the decision was his and his alone. And here we have emails from him saying that they want, quote, the high command looped in. He shows him in close communication with the Deputy Attorney General's office on an ongoing basis up until the days right leading to Abrego's indictment. This document, this ruling from Judge Crenshaw, really clarifies everything we know about this case, including, as folks who have been following very closely might know, this is based on a 2022 traffic stop from November 2022, where Abrego was pulled over in Tennessee and released without so much of it as a speeding ticket. Well, we now know, thanks to this ruling, that a investigation from Homeland Security Investigations was opened about a month later. And that investigation was eventually closed after the government spirited Kilmar Abrego Garcia away in March without so much as a hearing. And so that investigation was opened in 2022. It went cold for 3 years. It was closed. And then all of a sudden, after the Trump administration keeps losing in the district court, in appellate court, and in the Supreme Court, after that, prosecutors receive a copy of the Homeland Security Investigations case file and build a case in close communication. These documents, these emails show, with the Deputy Attorney General's office. And there are other emails in the days up to the indictment where Mr. Singh is talking about seeking clearance, presumably from Todd Blanche himself. And so these are a number of the emails that the U.S. Attorney's Office from the Middle District of Tennessee had suggested wouldn't exist because this was a decision that came from them. It didn't come from the top of Main Justice. It came from the Middle District of Tennessee. And this is something that Judge Crenshaw says apparently contradicts that.
And to be clear, that's the position of the Department of Justice. Oh, this couldn't be vindictive. It's an independent determination by McGuire. Let me say first, and thanks for that whole explanation. As a former U.S. attorney, when the Deputy Attorney General's office is involved, it's not mere collegial suggestions. The Deputy Attorney General will call the shots, and however nicely and politically McGuire puts it, if the DAG is on the scene, the DAG is in charge. Now, but it's more than that, so that we have that supposition and stands to reason. But remember at the time to review the bidding, as you say, Adam, a little bit more of the bidding. They swear he will never come back and never set foot in this country again. And the whole kind of tawdry chain of events since March is they're trying to make things miserable for him however they can, including in reaction to different court rulings. So now there's the whole tussle about, well, we'll send him to Liberia or we'll send him to Costa Rica where he wants if he pleads guilty. They've been really very focused on it. And when this came out, there was a clear sense of sort of pride by Bondi herself that they had done this jujitsu move. Okay, we have to bring him back for a little due process. Oh, well. But now we have him in criminal charges, which they swore they would hold to, and he would have to serve his whole time, and then they would deport him. It seemed clear at the time that this, like everything involving Abrego, was coming from the top. And that turns out to be the difference, at least in Crenshaw's mind, between a dismissal, and if this is a vindictive prosecution and the judge finds it, the case is dismissed. It's a due process violation. It's no longer got anything to do with the bona fides of the case. Even a solid case you can't bring for that reason under the due process clause. So now the entire prosecution is in, I would say, grave jeopardy, because now that Crenshaw has made he's already made, and we knew it, the preliminary finding, and now we get this document that you've just summarized, including radioactive emails that say this is a priority for the deputy. What the hell could that mean? Then the deputy is focused on it, and they're wanting to do it for the whole panoply of reasons that they're trying to immiserate Abrego at every turn for the grave sin of being mistakenly deported to CCOT in contravention of an extant order. So it seems to me that we know the sorts of documents that Crenshaw has seen, and his order, by the way, they had whatever, thousands of pages, but mostly were just reproduced files of what Abrego already had. And then there are these nuggets, what lawyers would call hot documents, and he has a table of them, 6 or so, that he's going to release. This would seem to me to really require the testimony of Todd Blanche, at a minimum, his deputy, who writes, this is a real priority for the Deputy Attorney General. That's a pivotal factual question, and how else are you going to prove it? But that sets up a situation that has to be anathema to the DOJ, right? So it comes the 28th, Abrego calls Todd Blanche to the stand. What do you think happens? How do you think what are the department's sort of strategic choices? How, by what sort of life support is this prosecution, which, as you say, was weak before it started, now hanging? What do we see as the dynamic leading up to the January 28th hearing?
I think that the government is going to do everything that it can to avoid having Todd Blanche be on the witness stand. They've tried to quash the subpoena. They have tried to quash the subpoenas of other top Justice Department officials. I want to read. There's one email that I didn't even mention that was from Robert McGuire, again, the acting U.S. Attorney for the Middle District of Tennessee, saying, "I have not received specific direction from the Office of the Deputy Assistant Attorney General, other than I have heard anecdotally that the Deputy Attorney General and the PDAG would like Garcia charged sooner rather than later." So
PDAG is the top assistant to the deputy. Yeah, go ahead. I
exactly.
think that was that Emile Beauvais at the time? Do we
Well, he was PA-DAG, I believe. So
Well, I think that's I think. Well, anyway, so that could be another little bubble to fill in here. Sorry, go ahead.
but that was days before the 3 days to actually maybe a little bit longer before Kilmar Abrego Garcia was charged, but
Yeah.
they would like to see him charged sooner rather than later. That's from Mr. McGuire here. So, as I was saying, I think that they're going to try to fight tooth and nail against Todd Blanche actually appearing on the witness stand, although that could backfire because, as Abrego's attorneys, led by Sean Hecker, have pointed out, the presumption of vindictiveness is on them. If you
Yes.
to show a legitimate purpose, you need people like Todd Blanche on the witness stand. So I think that the Trump's Justice Department is going to have to make some decisions. To what extent do they want to try to salvage this case, and at what cost? What are they willing to reveal to even have a shot to rebut the presumption? And by putting him on the stand, does that just make it much worse? Because again, these emails are now out there. We know that his top assistant, one of his top assistants, said that this was a top priority. We know that Robert McGuire said that this is another quote that I don't believe I have read yet, again, from the same date, May 15th. Ultimately, I would hope to have the Office of the Deputy Attorney General eyes on it as we move towards a decision about whether this matter is going to ultimately be charged. So he wants ODAG eyes on it. He's in constant communication. And again, he's receiving the case file from Homeland Security Investigations, which closed the book on this right after the Supreme Court says you got to take him out of CCOP. So they're going to have to make some tough decisions. They might decide, look, if it comes to saving the case or putting Todd Blanche on the witness stand, they might say that, isn't a trade that they are willing to make. So big things are going to happen in this case toward the end of January.
Yeah, I think that's really it, and that's the portent of this document. And I think they'll even have to resist tooth and nail having the court might settle for his assistant who writes the email, but I can't see going less than that. And just a couple things to add to the pot. First of all, I could be wrong. Maybe McGuire will testify, but to me, those are carefully laundered kinds of emails to give. They knew at the time it would be a better look if he's making the decisions, and we have indication that he's a loyal soldier. So I actually, to me, that even though even the emails sound a little bit contrived, remember to what efforts they went. The DOJ Bible says, do not cooperate up. Don't get, down. Don't get the mastermind to and what did they do? They find this guy in Florida who is saying, "Oh yes, I was the head of the whole operation, and I occasionally hired Abrego," and that's how they built their case. So they were straining against DOJ policy in order to do it. And I would just say, Adam, it seems to me if they're, Blanche is at least a strategic calculator, we've learned in the last month or two. It's 100% clear, I think, that the judge has what he needs to dismiss the case, right? To find they have. I mean, what are they going to do? They can always disbelieve whatever testimony is there based on the email, and I think they're probably going to conclude that's what's going to happen. So it's not it's a very bad look for them after how just vindictive and sort of unrelenting they've been against Abrego. But my guess would be if push really comes to shove and they know there's no way to avoid it except by dismissing the charges, they may do just that and then turn their focus to trying to deport him, but of course to Liberia or some other hellhole. And now we would be back with Judge Zinnes, who's saying, guys, come on, there's such an easy solution here. He agrees, but send him to Costa Rica. You said you'll do it if he pleads guilty to these threadbare charges. So that will be where the action goes. But we're not in the prediction business. We're in the informing business. Nevertheless, when I think of what the events and the discussions going on right now in the deputy's office, I can see them folding their tent before they let not just Blanche, but Blanche's deputy be on the stand, especially under circumstances where the official position so far advanced by the United States seems to be disbelieved for good reason. So, we're talking about really tough cross-examination and even the prospect of at least allegations of perjury against the Deputy Attorney General of the United States or a top assistant to him. That's a really very big, satellite brouhaha for them to fight.
Right. And I think one of the points you are making there is about the kind of deliberation through which how carefully both Judge Zinis and Judge Crenshaw have been moving, both with Zinis, it's in the habeas context, and with Judge Crenshaw in the criminal context. This is a vindictive prosecution hearing that's been delayed 2 times as he privately viewed this evidence, which he had determined to make public today. That's why we're talking about it. And we were originally supposed to have a trial at the beginning of the year. Instead, we will have the final date for the vindictive prosecution hearing. So this is a judge who's moving carefully. This is a judge who the Department of Homeland Security is now trying to vilify, no matter how much he has tried to accommodate them. And again, he has tried at every turn to accommodate them, just like Judge Zinis held evidentiary hearing after evidentiary hearing to get straight answers that she never received. And that's the pattern that's playing out here. And just a few days ago, you had the Department of Homeland Security attacking Judge Crenshaw because they said that he had put the agency under a quote unquote gag order. That gag order said nothing more than don't violate the local rules by attacking Abrego's presumption of innocence. As one of the commentators I've seen in the chat here note, the Department of Homeland Security was angry that Abrego has created a TikTok account where he can exercise his First Amendment rights to declare his innocence before his trial. And the Department of Homeland Security called Judge Crenshaw I believe they called him an activist judge because he told them that they need to obey the local rules for the Middle District of Tennessee and not make extrajudicial statements about a criminal defendant before that court. I mean, take a moment to pause and appreciate what the government making a public statement that it's a terrible burden that they are being forced to not slime a criminal defendant before his trial, and that only an quote unquote activist judge should make them observe the presumption of innocence that's protected by the Constitution and a cornerstone of a free society. That's the extremism that is being on full display here of a government agency saying that it's an activist judge that makes us not want to slime a criminal defendant before a trial.
Yeah, our end of year Substack talked about different district courts and their heroism, basically, and that's the absolute go-to manual by people who know nothing. Like Jeb Boasberg, you and I have spoken about in the context of these crimes, and absolutely respected on both sides of the aisle. But it just they have no hesitation in vilifying, is not too strong a word. Absolutely trying to dirty up, and with both Crenshaw and Zinn, they have no one to blame but themselves because they repeatedly bobbed and weaved and were squirrely and brought people forward who didn't know anything. And finally, the judges sort of hit the limit. This is a little bit of field, but just this morning, Adam, you may have seen there's this TikTok pretty famous guy in Southern California who has been charged with assaulting an officer there, and it's one of those. Did he assault or did they just totally, shoot him and brutalize him? But anyway, the judge dismissed it and against him, dismissed the whole criminal case. Very extreme thing to do, but basically said, the U.S. is lying or not being responsive and not giving discovery and trying to use the immigration system to prejudice someone on the criminal side. Just in general, district courts have become increasingly emboldened to, essentially just call it straight. And here it does really seem the straight call that come on, give me a break. Of course, this was part of their high-profile political attacks against Abrego, whom, remember, they said would never come back to the United States and would first do his criminal charges. This is just exactly what Todd Blanche and Emile Beauvais and others were doing in the early months of the administration.
Right.
Last
And I think
thoughts to you? Yeah.
Yeah, I think you're so right to talk about the reluctance of federal judges to take these actions and why these cases are playing out in this kind of glacial manner that we've been seeing. Why did it take several months and multiple evidentiary hearings before Judge Zinis had ordered the release of Kilmar Abrego Garcia from immigration custody? Why are we on our third date set for an evidentiary hearing in the criminal case? Because the government, when they bring a case, when it goes through an indictment, it is a drastic decision for a judge to dismiss the case. And if anything, for all of the rhetoric about, oh, this is an activist judge, no, this judge is being deferential. This judge has been granting the government opportunity after opportunity to show the legitimate basis of the prosecution, and has been seeing at every turn, oh, they're hiding the ball. And when they stop hiding the ball, they see the actual emails which reveal the motive underlying it. And so, to your point, Harry, that this is judges who are forced to take the constitutional action, which is in the Judge Zini's found, ordering the release of Kilmar Abrego Garcia from immigration custody, returning him to Maryland, which, as you noted, Kristi Noem said would never, ever happen. Where judges it wasn't a surprise to me that the case that you mentioned, that a judge dismissed, was happening in the immigration context, because this is where they're bending the rules. And judges are taking these actions after giving every opportunity for the government to show a lawful purpose for their actions, and they're falling short. And that's the story that gets buried underneath all the sound bites of, oh, this was a political action by an activist judge. Well, what preceded that decision? How many months of hearings, legal arguments, and what was the nature of the ruling? That's the part that the government always tries to gloss over.
Such an important point, and it goes to what, the Substack I mentioned about district courts. It's not as if they're like, actually hewed from a different, basis. They're judges, but they see it. They see what the government does. Now, they've both, as you said, done the extreme thing here, Adam, to actually dismiss cases, and it'll go up to the Court of Appeals, and we'll have the abstract, well, was it really justified on the dry record? But they're the ones who've seen the government be squirrely, and they've also seen in front of them the actual human cost to the people whose rights have been abridged. Okay, to be continued. Adam Klasfeld and I really focus on this case, but Adam of All Rise News covers the waterfront. Need I say more than that he was in Milwaukee in December this month to personally cover the Judge Dugan trial. So everyone check out All Rise News for all kinds of stuff, and check us out in Talking Feds when things concern, especially Abrego and some of the high-profile stuff. But Adam's your go-to guy for, cases that are really happening around the country. Always a pleasure. Happy New Year to you and yours, and talk to you later and soon.
Talk to you soon, and Happy New Year to you, Harry. Always a pleasure talking.
See you later.
See you soon. Bye-bye.